These are bad people, and they're paid a lot of money by rich people, some of whom we know. I'm sure I know some.
What names are we talking about?
Well, Soros is a name certainly that I keep hearing. I don't know, but Soros is a name that I hear. I hear a lot of different names. I hear names of some pretty rich people that are radical left people. Maybe I hear about a guy named Reid Hoffman. Somebody's a pretty rich guy, I guess, and I hear about him. I don't know, maybe could be him, could be a lot of people. We hear the same names, but they're bad, and we're going to find out. And if they are funding these things, they're going to have some problems.
A lot of these judges don't understand is that what Trump's doing right now is the nice way. The National Guard is the nice way. This is getting a lot of people very, very angry to the point that they'll support Trump's use of the Insurrection Act. An active duty, full-time military being deployed and having law enforcement authority and free to do essentially whatever Trump tells them to do within America's cities. That's going to be a party, and we're getting a little bit closer every day because these judges are going to compel Trump to do it the hard way by assuming for themselves these Article 3, unelected, black robe, tyrannical, inferior district trial court judges, assuming for themselves Article 2, executive branch commander-in-chief authority, the authority to make these calls about what it means for the executive officer of the United States, elected by the whole of the American people to carry out our political will, to be unable to enforce the law with the regular forces. By the way, I should update you all on that. I've mentioned it before. But of course, these cases are going to the Supreme Court. The Supreme Court has already agreed to hear them. And the Supreme Court has asked for more detailed written argument on what regular forces means in the relevant statute here. The statute is 12406. It provides for 3 grounds on which the president can deploy the National Guard under this particular statute. The president has other statutory justifications too, including the Insurrection Act. But under 12406 in particular, which is the one Trump's been using so far, there are 3 justifications. 1 is foreign invasion. That's not happening. 2 is when there's a rebellion or danger of rebellion. Well, that's obviously happening. These violent protesters are rebelling against the enforcement of federal immigration law. The way these judges get out of that obvious justification is they say, well, it's not really rebellion unless the entirety of the federal government is at threat of being overthrown. I would remind all of you that even the Civil War does not qualify under that definition of rebellion because the Confederate States were not seeking to overthrow the federal government. They had declared independence from the federal government and established their own confederacy of states. But they were not trying to overthrow Washington, D.C. They were not trying to overthrow Lincoln. They were perfectly happy to leave the North to go about its business. They just believed, with some reason, that they had voluntarily joined the United States and therefore had the privilege to voluntarily leave the United States. But they were not threatening the United States. They were not in a state of rebellion. They declared independence. So by this definition, not even the Confederate States would qualify as a circumstance under which the National Guard could have been called out by Lincoln. And then the third condition under 12406 is when the president is unable with the regular forces to enforce federal law. Well, that's obviously the case here because these protesters are besieging and blockading and attacking federal officers, disabling and blocking their vehicles, causing serious injuries to officers. Clearly, they're making it impossible for the federal law enforcement officers to enforce immigration with the regular forces that would do that. Now, the way the judges get around that argument is they say, no, regular forces means the full-time U.S. military, the professional, full-time Army, Navy, Air Force, Marines, Coast Guard, Space Force. Only if those regular forces are unable to execute federal law, only then would the president be privileged to call out the National Guard. I'll circle back. Does that make sense? If the Army with tactical nukes, if the Navy with nuclear submarines, if the Air Force with strategic bombers, only if they're not able to enforce federal immigration law, only then can Trump deploy the National Guard. That's the argument these judges are making with a straight face. The Supreme Court asked people to brief what constitutes the regular forces. So one of the conditions, as we talked about for Statute 12406, to justify the president calling forth the National Guard, is when he's not able to, with the regular forces, enforce federal law. And he's saying he can't. He's besieged. He's overwhelmed. His homeland security, his regular forces that would enforce immigration law can't get their job done because of the besiegement by these Antifa progressive fascist terrorists. And so he says, that's my justification for calling out the National Guard. Under 12406, I cannot enforce with the regular forces that I would use federal immigration law. And the opposition to that is, well, regular forces doesn't mean federal immigration law. It means the full-time professional military. I have talked about this. Sorry about that. But that's going to be apparently the key question before the Supreme Court, which they're going to hear. I think all those papers have to be filed by the 10th of November. And then there's another few days for people to file replies to the other side's arguments. So it'll be the end of the month, I would expect, before we have a definitive decision on 12406, Trump's deployment of the National Guard from the U.S. Supreme Court. But it is heading there. And of course, that will wipe all this nonsense away from the unelected black-robed, tyrannical, inferior district trial court judges and even the Court of Appeals decisions. Even the en banc Ninth Circuit Court of Appeals decision that's currently in the works, all of that will be wiped out by whatever the Supreme Court decides by the end of the month, which kind of gives away how much of this is theater, doesn't it? And Justin writes, $20. That gets Justin 4 ka-chings. 4 ka-chings. We tend to parcel them out in $5 increments. He said, I would respond with regular forces being what the on-site MTOE states, what is used for normal business operations, terms of engagement, I believe, right? Then add a time hack for how long special response teams are used to support operations at a particular work site. Yeah, so the issue I think we're going to run into, I mean, it's not an issue, it's the lie that they're telling, is that there are many statutory provisions that refer to the regular forces, like when the context is, how do we differentiate between the full-time professional military on the one hand and the National Guard on the other? When that's the distinction we're making, it makes sense to use the phrase regular forces to refer to the full-time military and National Guard to refer to, no offense, National Guard, but the part-time military, the weekend warrior part-time guys, right? How's it work? A weekend a month and 2 weeks of summer, whatever it is. But it's not the full-time military, right? These are people with normal jobs, normal careers, that kind of stuff. And to their enormous credit, they volunteer a substantial part of their time to the National Guard. By the way, it could be very substantial if they're called up and deployed, right? But in that context, if we're talking about statutories in the context of full-time military and National Guard, what terminology would we use to distinguish between those two? Regular forces make sense. Regular, as in well-regulated, like in the Second Amendment, right? That concept, like a regulated machine, a well-ordered machine, a dedicated machine. It makes sense to call the military forces the full-time military, the regular forces in that context. So that's the lie they're trying to sell. Of course, here, the context is not only different, it's the opposite. It's the opposite, which is why the argument doesn't work from a reasoned legal analysis perspective. Because regular forces in this context cannot apply to the full-time military. It can't. It's impossible. Why is that? Because we're talking about regular forces for what purpose? Enforcement of federal law. Well, the full-time military is not allowed to enforce federal law. That's the Posse Comitatus Act. So you cannot use the regular forces to enforce federal law unless you've invoked the Insurrection Act. But 12406 is not the Insurrection Act. If you've invoked the Insurrection Act, you can do whatever you want. So 12406 is conceptualized as the Insurrection Act has not yet been invoked. This is a preliminary means, short of the Insurrection Act for deploying the National Guard. So the Insurrection Act has not been invoked. If Posse Comitatus is in effect, and 12406 does not set aside Posse Comitatus, you simply cannot legally use the full-time professional military to enforce federal law. So the question cannot be, The regular forces in the context of 12406 cannot, with the regular forces, enforce federal law. It can't mean the full-time military. It wouldn't make any sense. So it can only mean the regular forces you would use for the enforcement of federal law. And that would be ICE, Border Patrol, etc. And really only a subset of those. Really only those that would be the regular forces for that legal context, for that geographic area, for that office. If you have to send in additional officers from outside the region, well, now those depleted offices, the source of those additional officers, cannot execute federal law with their regular forces, and it would trigger the president's ability to deploy the National Guard. So, to my mind, that's where the Supreme Court should, and I expect will, come down. Hopefully, John Sauer, the Solicitor General for the White House, is about to make that argument. Hopefully, he's writing that argument this week to file it with the Supreme Court by the November 10th deadline. John, if you're watching the show, man, that's the argument right there. All right? So, love your work, man, and I'm sure you'll catch it. I know you will not disappoint me. I'm sure sometimes John Sauer goes even a whole day without thinking about how he can avoid disappointing Attorney Andrew Branca, but that is the argument, my friend. Yeah, I would also argue that regular forces can arguably be contextualized for the times. So, for example, my buddy Shipwrecked Crew, Bill, a former federal prosecutor, he argued with some merit, we had a very pleasant exchange on X, that at the time, not 12406, but the predecessor statute on which it's based was passed. The regular forces were much smaller, actually, than the state militias, what we now call the National Guard. And in that context, it might make sense to call out the smaller military organization, the full-time military, rather than the larger state militia. And of course, those proportions have now been reversed. But it's possible the predecessor to 12406, when it said regular forces, it was thinking of the full-time military. And my argument there would be, it still doesn't make sense in the context of Posse Comitatus, but even if we set that aside, the statute doesn't say full-time military. It uses the phrase regular forces, and regular forces is like an empty bucket into which you place whatever would be the regular forces in the relevant time period. So even if regular forces might have meant, that bucket of phrase, regular forces might have meant full-time military 100 years ago, well, the world's changed. Now the regular forces for this purpose of enforcing immigration law are ICE and CBP. So that's where I'm at that. Yeah, so I do want to address this. It's not a super chat. This is about getting notifications of the shows. We are in the process, folks, of setting up an Andrew Branca Show website, independent of YouTube, and we'll give all of you an opportunity to sign up there. There'll be a free sign up. There'll be a newsletter. There'll be, the kind of stuff that shows like mine normally do. And if you do that and you provide an email, maybe a text, I'm not sure what the technology will look like, then we'll be able to communicate with you without having to rely on these very imperfect YouTube notifications. YouTube is very weird about when they send out notifications. So we're going to set that up. And also, by the way, that way of, every day I go to do this show and I don't know if I'm going to have a YouTube channel. You know how YouTube is. So it would be a great way to have a parallel membership structure just in case YouTube goes crazy. But that's in the works. Also, next week we will have mugs. I won't be using my Law of Self-Defense mugs anymore. We will have Andrew Branca Show mugs, at least prototype mugs. We ordered 4 prototypes. So we'll see what they look like when they get here, and I'll show them to all of you. We may come up with a few different versions. But I think they'll look nice. So that's where we're at with that.